Vladimir Putin does not respect international law. Peter Dean, Chief of Foreign Policy and Defense of the U.S. Marine Corps, said Russian President Vladimir Putin had disregarded international law. Mr. Dean told Sky News Australia he is not one to respect the power of other countries. Jeffrey D. Kahn, assistant professor of law at Southern Methodist University, said at the Kennan Institute conference on April 17, 2008, he said he created it. But there are not enough laws in Russia. Mostly there is no legal culture. Kahn focused on three legal windows under the Putin regime: the Second Chechen War, Russia's entry into the Council of Europe, and Putin's codification work, particularly the new Code of Criminal Procedure. These three windows offer different perspectives on the legal situation in Russia. The first is gloomy, the second is hopeful, and the third is indecisive. Reflecting on these points, Kahn said, "Our short-term expectations should be low, while our Russian legal standards should be high. The Russian government's measures and public adherence to these standards should be strict." As Prime President Vladimir Putin immediately faced renewed insurgency in Chechnya and bombings in Moscow and other Russian cities. With the support of the people, Putin immediately began military operations in Chechnya. Kahn said that Putin defined the war as a fight against terrorism and used this as a justification for the centralization of power. Putin's war hindered the development of the right to state. As Russia's military action in Chechnya continued, Kahn observed, a rumination on the right spread to the north of the Caucasus, as everything was covered with a sticky patina of violence. Russia's involvement, however, with the rise of Putin's power. The Council of Europe had a great influence on the law in Russia. Regarding Russia's second window, Kahn said, "I think history will show that the European Commission has done more to promote the rule of law in Russia than any other organization, environmental policy or actor, by allowing Russia to join. The European Commission risked undermining the credibility of the company by Russia's failure to comply with Commission rules." Another source of tension turned out to be the case the European Court of Human Rights received from Russia. Russia now accounts for more than 20% of the 4 documents in question. However, Kahn believes that Russia's recognition of the ICJ's jurisdiction is important enough for the rule of law to be worth the risk. While the court assesses the compatibility of Russian legislation with the European Convention on Human Rights, which Russia has ratified, Kahn sees every decision as a recipe for further reform. Kahn noted that when Russia lost a successful case before the ICJ, the court demands respect from the current Russian leadership. Russia's representatives before the court complied with its rules, and the Russian state paid all judgments against the court without exception. The third window of Kahn's law reform is the completion of a new law. "I think the best reform of the Putin era was reform of the criminal justice system," Kahn said. The reforms were driven by Russia's quest to join the Council of Europe and led to major changes in Russia's criminal code. "Apparently, there is an improvement in the US system," Kahn said. For example, unlike the USA, the Russian police do not allow arrests of persons for crimes for which imprisonment is not a crime. The right to arrest people was transferred from prosecutors to judges, and they were also given the power to issue warrants to search houses or confiscate property. The right to a fair trial, as well as greater protection for defendants and witnesses, is written into law. Khan added that his explanation of major changes in the law reflected what was written, not actual practice. There are generations of police officers, prosecutors, judges, and defense lawyers trained by the old government, Khan warned. However, as older people resisted reform, they were increasingly replaced by younger professionals from the new group. How can we reconcile the benefits of change in ordinary situations with the destruction of transparent governance in high situations? Khan said the short answer is we can't. States use law as a political tool to suppress dissent, thereby undermining respect for the rule of law. But a balanced response takes into account that the new penal code makes political experiments more difficult, or even impossible, Khan said. President Vladimir Putin recognized the two regions of eastern Ukraine controlled by Russian-backed forces as an independent state. On February 21, President Putin signed two laws recognizing the independence of these two regions and sent them to parliament for approval. He then ordered Russian troops stationed on the Ukrainian border for several months to carry out peacekeeping operations in what he called the Donetsk People's Republic, DNR, and Luhansk People Republic, LNR. On February 22, the Judiciary Committee, the upper house of the Russian parliament, approved Putin's request to send troops. Putin said on February 22 that the autonomous border is the region recognized by Russia. Extends to most of the Donetsk and Lugansk regions under Ukrainian government control. Get updates on human rights issues around the world. Send it to your inbox. Clashes in eastern Ukraine's Donbas region are escalating as Russia steps up unprecedented military operations on the Ukrainian border. Since mid-February, the Special Monitoring Mission of the Organization for Security and Cooperation in Europe, OSCE, has reported a daily increase in 2014 document conflict of agreement violations in the contact area. Despite the self-proclaimed label, the Russian military in Ukraine retains its powers in accordance with international law, including the Geneva Conventions. The situation in eastern Ukraine would fall within the operational area, defined by the Fourth Geneva Convention of 1949, as explained below, if the Russian army entered the area. There is no claim of control where local authorities refer to them as LNR or DNR, or recognition of their independence by the Russian government, which affects the use of the international law position. Clashes between government forces and Russian-backed forces in eastern Ukraine resulted in serious civilian casualties. The conflict, which lasted nearly 8 years, has killed more than 16,000 people, both combatants and civilians, and displaced nearly 1.5 million people. The conflict also caused extensive damage and destruction to civilian infrastructure, including homes, hospitals, and schools, on both sides of the 427-kilometer line of contact that separates the territory controlled by the Ukrainian army government from those controlled by the armed forces. How does international law apply to the war between Russia and Ukraine? The brutality of the Russian and Ukrainian forces led to an international conflict governed by international human rights law, mainly the provisions of the Geneva Conventions of 1949 and their first supplementary act, Act 1, of 1977 and the H-Aid Act of 1907, Laws of War and Methods, and provisions of international human rights law. Both Ukraine and Russia are parties to the 1949 Geneva Conventions and Protocol I. What is the war principle? International humanitarian law or the law of war protects civilians and other non-combatants from the dangers of armed conflict. It influences the behavior of violence, the methods of warfare between the two sides of the conflict. Most important are the rules by which parties to a conflict must distinguish between combatants and civilians. Citizens cannot be deliberately targeted. As explained below, both parties to the conflict should take every precaution to minimize damage to civilians and public property, and to avoid engaging in armed conflicts that do not discriminate between civil and war or harm civilians. Does international human rights law still apply in Ukraine? This is true. International human rights law has always been and continues to be applied as the law of war, including in times of conflict and occupation. In some cases, human rights laws may override human rights, such as special lexicon or specific norms for specific situations. Ukraine and Russia are parties to several regional and international human rights conventions, such as the European Convention on Human Rights (ECHR), the International Covenant on Civil and Political Rights (ICCPR), and the Convention on Inhuman or Degrading Treatment or Punishment (CAT). These treaties express recognition of fundamental rights, such as the right to humanitarian assistance, many of which are common to war-affected and civilians under international law. G. Prohibition of torture and ill-treatment of people, right to a fair trial without discrimination. While both the European Convention on Human Rights and the International Covenant on Civil and Political Rights allow certain restrictions to be placed on certain rights due to threats to the life of the country, during war or when a state of emergency is declared, public crisis, all reductions in rights must be private and temporary and should be limited only as the situation requires. Some fundamental rights, such as the right to life and the right to be free from torture and other forms of violence, the prohibition of imprisonment, the duty to monitor the judicial process of legal detention, and the right to a fair trial, must be protected even in public settings. Emergencies should be treated with respect. What could be the legitimate aim of a military attack? The laws of war forbid attacks on military targets. Military targets are people and objects that contribute to military action, destruction, capture, or attack for the benefit of the military.